Good morning, Con. Good morning, Gareth. Good morning, Lisa. Good morning, Henry. Morning, Derek. Welcome, welcome, welcome. Many thanks for joining Pension Playpen this morning. We will ask you very kindly to mute, please, if you have just joined, so we can cut out any background noise. Morning, Derek. Morning, Brian. Morning, Sapna. Morning, Steph. Morning, Barry. Morning, Adrian. If you've just joined, if you could mute, please, that'd be great. Thank you very much. Morning, Chris. Let's just put that on mute. There we are. And Chris, I'm going to mute you as well. There we go. Excellent. Thanks for joining. Morning, Shay. Thanks for joining as well. If you could mute, that would be excellent. Thank you very much. Perfect. Okay, Rosalind, it's 10:32. Before we start, by the way, it's Rosalind's birthday. So can we all give her a virtual clap for happy birthday, Rosalind? So there we go. And
I'm even older today.
I said to her, what present would you like? She said, I'd love to present on Pension Playpen. So I've arranged it for her. So there we So there we go. But welcome, everybody. Thanks for joining this week's Pension Playpen. Delighted that Rosalind Connor from Temple Bright is on. She's going to be talking very passionately about the subject, which is we want less law in pensions. I know there might be a little bit of a political thing going on as well there, Rosalind, as well. But because it's your birthday, you can say what you want. So there we are. So that's an open piece of paper for you to go for. As usual, we are recording. So thumbs up for anybody who everybody's happy to be recorded. And I'll just bring Barry in. And if you'd like to put any comments in the chat, please do. And if you would like to challenge, agree or disagree with Birthday Girl, then please raise a hand. Ros got a few slides. If anybody wants the slides at the end, please email myself or Henry Tapper, and we will get the slides to you. But without any further ado, Rosalind, over to you. Do you want us to sing happy birthday to you before we start? Or no, it's all right, fine.
I'm actually slightly worried about the idea that I can say what I want because it's my birthday, because I've just thought, does that mean for the other 364 days of the year I can't? Because that would
correct. Yeah, exactly.
So thanks very much. I'm going to try and share a oh gosh, it's doing exciting things. Right, I'm going to try and share my slides, and because I've got this on full screen, I won't be able to see anything else. So if anyone needs to interrupt me, please, I suspect through Steve, you might need to sort of shout. I'm going to run through the slides. My thought with these slides is they shouldn't in any sense take up all the time we're talking. I think I'm hoping to provoke a bit of discussion on this subject. So what do I think about that? I'm going to start by explaining what my basic argument is, then I'm going to go into some of the detail of it. I really love to hear other people's views. So this is my basic concern, that I think politics as against policy in pensions leads to too much law. I should be clear that I don't really see this as a political statement in the sense of thinking one party is dramatically better than another. I think the last 30 years or so, pensions has come more and more into the political fray, and I don't think it's been good for us. So mostly, my basic argument is this. I think politicians regularly promise to review pensions, and sometimes they say they're going to solve it, and that always puts ice in my heart. Manifestos these days all have a pension section, and they have for some years. As I say, I think if you go back 30 years, that's a kind of period over which this has developed. But the last 10, 15 years, everyone has a pension section. Each time there's a new initiative, each time someone's reviewed things, there's a new statute, there's a new Act of Parliament, which sometimes isn't just one idea, it's about 4 or 5 different, completely different ones going in different directions. And all these, because there are so many of these, they compete for the attention of the industry and the time and the resources of people providing pensions or working in the industry. And they're not always consistent, let's be honest. So do we need this much law? It's going to be a bit of a spoiler. I don't think so. I think we can do with less of it.
Ros, sorry,
So,
just to interrupt. Can you put it on full display mode? Bryn has asked, is there a little? If you look at the bottom, you might be able to put it on full screen display mode.
oh, I thought I had it. And hold on a sec. I might need to have to do something slightly complicated to do that. Hold
No,
on
no,
a
no,
sec.
no, sorry. So only
Does that help? Is that better?
that's better, but that's fine. If that's what we can do, that's what we can do.
That's
That's
as
fine.
far as
Yeah,
I
yeah.
can get. That's
That's
full
fine.
screen.
Cool. Yep, yep, yep. That's fine.
So is pension special? So this is my question. Do we think that pensions are different from other things, and that's why it's like this, or are we thinking that the rest of the whole universe is treated the way pensions is? I think we have a great tendency in the pensions world to assume either everything else is exactly the same or everything else is different. So I thought I'd look in some other sectors. So I thought I'd start with financial services. So financial services are heavily regulated, just like pensions are, for largely the same reason, which is basically it's individual savings, and there is a massive disparity in knowledge and understanding between providers and consumers. I mean, I don't know about, I mean, I'm sure most people on this call are much better than me, but I don't understand my savings and investments. I have someone who does that for me because I don't understand it. Whereas when I buy myself, I don't know, a holiday, I definitely understand that. I understand what I'm getting, and I understand if I don't get what I was expecting. Don't really understand that with ISAs. I just have a vague idea. I have an idea of the tax structure, and then I leave the actual investment stuff to other people. So, financial services are very similar to pensions in that way, that there's that disparity. So financial services have had one act of parliament since 1990. I said I was going back about 30 years. Pensions has had 25. That means acts of parliament, primary pieces of legislation with the word pensions in the title. There's loads of other legislation that affects pensions, but acts of parliament that specifically mention pensions have been 25 to 1 in financial services. I said this to a colleague of mine who's a financial services lawyer, and he said, yes, but the Financial Services and Markets Act is a really big act. And I said, we've had 25. And he said, yeah, okay, you win. And the point about this is nothing else really gets that except tax. Tax law, there has to be a new act every time there's a budget that is to do with complicated constitutional law stuff. So tax always has an act of parliament. The only thing that comes close to it in terms of the number of bits of legislation that are ongoing and that take you off in different directions is pensions. Nothing else really does. And I think that's really interesting. So I think legislatively, we are different in pensions. I also think we are politically. So I made this comparison because between the last two pension scandals, BHS and Carillion, there was Grenfell Tower. And the response of politicians to Grenfell Tower was to say, this is awful. We really need to have a look and see if we need to change the rules that firemen have to go by in how they evacuate buildings. Change perhaps the rules on what evacuation routes there are from multi-story buildings, and do something about people putting flammable cladding on the outside of them. But the level of sort of worry and heightened distress doesn't to me feel as if it was as high as we got from things like BHS and Carillion, or at least they were equal. And I think that's really interesting because although I wouldn't have wanted to be a Carillion pensioner, I think we'd all prefer to be that than a tenant of Grenfell Tower. It's interesting that pensions got just as much sort of anger and frustration coming out in the press. Interestingly, again, if you look at most of the manifestos, they don't really have anything about safety in public housing, but they've all got something about pensions. So again, it's interesting. Pension seems to stay in the public eye. And incidentally, I don't think the answer is that Grenfell Tower is a one-off and there's never been other problems with council housing. Obviously, Grenfell Tower was particularly bad, but every now and then we do get gas explosions, very often on council estates because they're less well maintained because less money is spent on them. There are safety issues with public housing that exist and probably exist in every economy, but it doesn't get the same discussion as pensions does. So it's odd that pensions is getting so much more. And so then I thought, do pensions get the same thing, the same level of political sort of profile in other countries? And I don't think so. I did a sort of quick comparison of Enron versus BHS. So you would be forgiven if you read the press around the time of the BHS collapse for thinking that the only thing that happened in pensions, in BHS, was a pension scheme, because there seemed to be so much more discussion of that than, say, the fact that loads of people got lost their jobs, or that people who actually did rely on those shops, although obviously fewer people than before, hence the financial difficulty, no longer had them. And I thought that was really interesting. If you compare that to Woolies going bust sort of 10 years before, there was no mention of the pension scheme, even though there was a pension scheme, but there was a lot about people not having access to the shop and about people losing their jobs. Whereas if you look at Enron, virtually no mention of the pensions, even though there's a really juicy, if you like, pension scandal. Enron had a 401k, which is like an American GDP, which, because that's standard in America to do it this way, was largely invested in Enron stock. You could move out of it, but there are always restrictions, and you only do it a bit at a time. So when Enron collapsed, the rank and file employees lost their jobs and their pensions were 60% in Enron stock. Now, so far, so well, you haven't got a rule on employer-related investments, you fools. But actually, it's worse than that. 401ks have blackout periods where you can't trade for a whole range of reasons, usually administrative. Possibly coincidentally, just as the stock price started to slide with Enron, they entered a blackout period. So none of the rank and file employees could do anything about the fact that all their savings were in this Enron stock that was losing value. Of course, the executives could, because theirs wasn't in the 401k, they held it directly, and they, of course, all offloaded theirs, which accelerated the collapse. So basically, the executives got their money back, and the rank and file employees lost all their money in their pension. That's the kind of pension scandal I want to sell to the socialist worker. If you want to have an argument against capitalism, it's something as appalling as that happening. So what I'm saying is Enron has a juicy pension scandal. They didn't really get much airtime. Whereas with BHS, even, people were asserting many things that weren't happening about how awful things were of BHS with the pension scheme, and didn't seem to be interested in other things. So I do think in the UK, we treat pensions as a special case, and I'm not sure we should. Right, so I'm really sorry, but before I can get into my argument, I'm going to have to do a little bit of boring law background. I don't know how much people who are not lawyers know what I'm about to explain, but I sometimes find when I'm talking to particularly policy people that they're actually very, very unaware of this. So I'm going to explain it, and I'm going to do it as quickly and entertainingly as I can. Law basically comes from two places. There's legislation, which is acts of parliaments and regulations, which is known as black letter law, i.e. it's written down and we can all go and read it. And then there's common law, which is often referred to as judge-made law, which is not a phrase judges like, because they don't like to think that they make it. They don't want it to sound like they sit there one morning and say, I'll make a new law. But it's the law that develops from cases, from someone just turning up in court and saying, this isn't fair. And over time, law develops. So nearly all the law we use day to day, certainly in going to court and suing someone, is common law. So contract law, which has been developed over the last 300 years, trust law, which has been developed over the last sort of 800 or 900 years, and various other torts all exist entirely under common law. So legislation can sit on top of them, but legislation isn't the cause of that law existing. The reason I'm emphasizing this is that in some ways the bulk of law is common law, and common law is very, very strong and important. People tend to assume that because it's not written down as a law, it's not really a law, and it's somehow something ephemeral that's not really there. And that's simply not true. To give a good example of this, the only reason anyone can sue anyone for negligence in this country is because in the late 20s, early 30s in Scotland, a woman bought her friend a bottle of ginger beer, and the friend who opened the bottle of ginger beer drank from it and discovered a snail in it, allegedly. And the person who'd bought the bottle couldn't sue because he hadn't suffered a loss. And the person who had suffered the loss, the friend, hadn't got a contract with the person who sold the bottle of beer. So the court said, yeah, you're right. You should be able to sue. You should be able to sue for negligence because people should be aware of the effect of their actions. And if you're going to have a radical effect on someone, you should be aware that people are not going to be happy if they have a snail in the bottle of ginger beer. That case is called Donoghue and Stevenson. Lawyers love talking about snails and ginger beer because all negligence cases come back to that case. So I'm trying to illustrate from that, but law is not just about legislation. And in many ways, it's not mostly about legislation. A law saying you shouldn't do something is probably not actually written into an act of parliament. Added to that, legislation is interpreted by judges. So most cases involve both common law and judges looking at legislation and interpreting it in terms of their existing common law rules. So common law kind of affects how we interpret legislation, where you could take it more than one way. So 2 points about who wins. My opinion on what the law says is trumped by whatever a judge says. So if a judge sits there in court and comes to a conclusion about the law, that is the law, even if all the lawyers say, I think they've got that wrong. So you may have heard lawyers whinging about, and we all do a bit, about part of the Lloyd's judgment, the GMP equalisation judgment, that talked about things about forfeiture, which we don't think, well, a lot of people don't think quite is the right way that should have gone. But that's not really relevant. That's what the law is, whether we like it or not. So judges' opinions trump ours, even if we think we're better. And obviously, most lawyers think they're better most of the time. The other thing is that legislation trumps common law. So although common law is most law, and it's big and it's strong and it's important, if you don't like the way the law is, if you don't like the way it's working, there is a simple solution to that. You start a political party, you get a majority in the House of Commons, and you change the law, because the government can do that. They can say, okay, well, the law says this, but I don't want it to say that. So you change it. So that is, apologies to people for whom all that is obvious, but I'm surprised how often I meet people for whom it's not. And the problem with having been a lawyer since my mid-20s is that I can't remember what things I knew anyway and what I didn't when I wasn't doing law. I hope that isn't too dull for everyone. So that brings us on to my big argument, which is about whether old law or new law is better. By old law, I mean the existing statutes and the common law, or being the political party that I've just started and got a majority, the new law I bring in. Well, the advantages of old law are the following. Common law is much more nuanced and much more precise. And by precise, I mean particularly it's precise in its scope. It's precise over what it covers. One of the hardest things about developing a law and writing a law, if you want to sit down and write it in statute, is working out exactly what you mean. So to give an example, when I started doing my law exams, we had to do this sort of exercise in which we tried to develop a law on whether it should be illegal to stab someone. Well, you'd think that's really straightforward. Of course, it's illegal to stab someone. Well, what if by stabbing someone, I stop them, murdering a large number of children in an orphanage with a big bomb? Well, I suppose then it's okay to stab them. But do I need to be careful to make sure that there wasn't a less aggressive way to stop them blowing up the children? Or do I need to? How sure do I need to be that that's what they're about to do? I certainly can't walk down the road and say I stabbed this person because it looked to me like they were going to go and get a bomb and blow up and all. And then what about a surgeon? A surgeon stabs me. Oh, that's okay because I consent. So it's always okay if I consent? No, it's okay because it's good for me. So it's always okay if the person stabbing me thinks it's good for me. What I'm trying to illustrate with this is that law is very much about asking yourself the questions about when it applies and when it doesn't apply. And it's really, really hard to write that out clearly. And you can't do it by a list of acceptable scenarios. You have to do it by principles and explaining how those principles apply. And what happens with common law, of course, is you have a law described a certain way, then someone comes up with a counterexample. That's specifically what the case will be. And the judge has to say, okay, I've got to not only decide whether or not it applies in this situation, but why. And that why, the ratio, explains what the law is. So common law is extremely good at telling us how circumstances should, our current circumstances should be applied in terms of the law, how they fit with where the law is, because that's what has happened over centuries. I'd also say older law, both common and statute, is clearer. It's better understood because there's been case law about it, and uncertainties in statute have been clarified over time. Clarity is incredibly important for law to work properly. People can't follow laws that aren't clear. So I've mentioned chair statements here. The big problem with DC chair statements when they came in was that loads of people got it wrong and got fined, and there was a compulsory fine. Okay, fine. That's, that is how it is. There's a fine, but that isn't really a success here, because, okay, some of those people were definitely not going to obey the law unless someone fined them until they did. But most of them either didn't really realize the law applied, there's quite a lot of that, or didn't realize or try to comply with it and didn't get it quite right. So that isn't a success. And it's noticeable actually with the guidance, the draft guidance the regulator produced for statements of strategy. They've put a standard form in there because I think they recognise that it wasn't a success with chair statements, that loads of people got fined. Much better to say this is what we actually are expecting, so that people have a better idea of what they're doing. What I'm trying to illustrate with that is that uncertainty there meant that we didn't actually have a very useful law. We just had a whole bunch of people being fined, which didn't achieve anything. What we want is the chair statement to be like. So why is new law good? Well, new law is definitely better if you want to move the law in a radically new direction. If you're looking at what's there over time, accretively, the common law is probably going to help refine it and it's going to get better. But if you want it to go in a different direction, you probably need to look at a new law. That's what you need new laws for. Brutally, also, new laws are really good at making politicians look like they are achieving something. There is an awful lot of law that has been passed over recent years which replicated existing law, but it was a good banner waver, what my children would call it, a good virtue signaler. To give an example, there was an upskirting act. So when people started having really nice quality cameras on their phone, some people developed this charming habit apparently of going into crowds and shoving a camera under some woman's skirt, and so they could take a picture of, what they see under the skirt, which I'm sure was lovely. And then they post it online or various things. And there was a suggestion that there needed to be an upskirting act, and there was lots of support for it. And all the people who know about sexual offences law, criminal barristers and the like, were saying that there is law already. It's not about cameras, because the law is the Sexual Offences Act, which I think is the 60s, but it covers things like taking pictures of people that weren't expected while they're getting dressed, or whatever. It covers similar things. So you could have used that law, but it was great to say, we're going to stamp this out by having a special law for it. And it then, of course, meant that anyone who said, well, haven't we already got a law? Why don't we just say the police should use the full force of the current law? Got people saying, oh, so you think it's okay, do you, that this is happening? Which, of course, is not what they're saying. So there's become a political thing, I think, that of saying, this thing is bad, I'll have a law about it. That shows I'm doing something as a politician, which, obviously is not what all politicians do. I think it would be very unfair to suggest that, but certainly a number of them have, and certainly around pensions. So I'm just going to mention a phrase that lawyers use a lot, and like a lot of things that lawyers say, it's taken me years to understand it. I mean, at least this one is not written in a dead language, but it took a while to understand what hard cases make bad law means. Hard cases make bad law is basically saying you shouldn't use extreme examples to pass legislation because you'll regret it. And the example often used is the Dangerous Dogs Act, which is, I think, 91. What there've been is a series of attacks by dogs on people, and people have been hurt, and in some cases people have died. It's been quite nasty. And so they passed an act of parliament that basically said if you had a dog belonging to one of these specific breeds, then there were various rules and it had to be muzzled in public, you had to do various things with it. It had always been the case, of course, that weaponizing dogs, using them as attack dogs on people, was illegal. You're using it as an offensive weapon. But this was in response, certainly, to a lot of outcry in the media. And it was heavily criticised because, of course, people who bring up their dog to be an attack dog aren't going to obey the law. And the people who did obey the law and had dogs in these apparently quite distressing and sometimes quite painful muzzles and all these other rules around them were people who had trained the dogs properly. And the evidence seems to be that actually it wasn't so much about the breed of the dog, but it was about how you trained it and how you looked after it. So it really has been a highly criticised bill. And of course, what it certainly didn't do was prevent dog attacks. There still continue to be them, often from breeds that weren't on the list. Who knew? So the point is, you shouldn't look at one terrible thing and make your law from it. And I think that has happened in pensions a lot. Law is supposed to attempt to affect behaviour. So yes, it's supposed to punish bad behaviour, but it's supposed to also reward and encourage good behaviour and help people to get to a place where they behave well. When I had my children, I remember being very annoyed at a leaflet we all got from the NSPCC as new mothers that basically said, if you hurt your child, that's a criminal offence and you're going to prison. And I found it a really frustrating leaflet because what it didn't anywhere say is if you do feel after 3 weeks of no sleep and this thing just screaming endlessly, like you are at the end of your tether, maybe go and sit down with a cup of tea, or maybe call a friend, or even here's a phone number, phone us up, vent at us, and then you'll go and be sweetness and light with your still screaming child. It felt to me like it wasn't trying to affect behaviour, just threaten, which doesn't really help very much. So focusing on punishing people actually takes you away from trying to encourage and support good behaviour. It also doesn't punish the most likely issues. If you are focused with pensions, for instance, on people who want to steal all the money out of the pension scheme, you're not focusing on people not keeping their data up to date, which is a more common issue that needs to actually be thought about and is happening a lot. I think there are two issues. One is that bad people will find their way around the law. So they brought in the Pensions Act 95 in part because of the Maxwell scandal. But a lot of the changes they brought in there, Maxwell complied with. One obvious example is he had several member trustees. He liked having member trustees because Maxwell was a really nasty bully. And he could terrify people who worked for him, particularly in junior roles. They were all utterly terrified of him. So he loved having member trustees because he could really mess them about effectively. Also, if you get to really bad people, by which I mean criminals, they don't care what the law says. I thought it was very interesting when the legislation came in saying it was basically a criminal offence to cold call people to get them to transfer their pension. A large proportion of people trying to get you to do that, and certainly most of the scammers, were criminals. I understand there are lots of connections to organised crime and to terrorism. People like that are really not going to be affected by the fact there's another crime going on here because it's by no means the biggest or the nastiest crime. So bringing all this together, what do I think is yes?
Sorry, just to say that we have mentioned that we are seeing slide 3 at the moment. What slide are you on?
Oh dear.
Just asking. It's 11 o'clock and I thought, well, maybe we're going to go to slide 4, but I don't know. Maybe you can't see what slide you're on, but we're on slide 3
no,
of
I
10.
thought I was moving. I think I was moving forward. I'm so sorry. Right, let me reshare. So I had some really good slides there, which you've all missed, but they were really nice. Just take it.
Oh.
Let me just right.
It's fascinating what you're saying, by the way, Rosalind.
Focus. Can you see that?
We weren't seeing slideshow, so that's better.
Can we see it now? I'm so
Yeah,
sorry.
I can see that.
Honestly, the last slides were brilliant. But no, seriously, they didn't say anything I didn't say. So So what do I think is wrong with pensions legislation? Fundamentally, I think there are far too many different bits of legislation. The legislation isn't incremental, it's all going in different directions, lots of different things. And whenever it's passed, it doesn't seem to take account of existing statutory law or common law. It really doesn't take account of common law. And the policy can be contradictory. I mean, the obvious example, as was actually being discussed last week, is at the same time that we had the Mansion House speech and, hey, look, it might be a good idea if we actually took a bit more risk in our pensions portfolio and cared about the UK equity market. At the same time as that, we were having people we're having people in the DWP putting together the regulations which were to do with making sure that we were more prudent in our investment of our DB scheme. So it wasn't directly contradictory, but it was kind of a lot of contradiction. And at the very least, they should have been addressing each other's approach. And I didn't feel anyone did that at all. It was almost as if they paid no attention to the existence of each other. So what does this result in? Well, I think it results in very significant cost to pension schemes. Anyone who's ever been involved in a master trust will be aware of the vast amount of time and money that needs to be spent in a DC scheme with lots of tiny little DC pots, complying with real reams and reams of regulation and running everything by the pensions regulator and checking that you've got everything done exactly the way they want it done. I'm not saying any of those things are bad. It's just they do feel a bit like overkill when we compare them to other industries where nothing of the kind happens. I think a lot of the groupthink behaviour that we see in pensions, and we're great at self-flagellating and saying, oh, we're terrible and we have too much groupthink. And there is a lot of that. I think it's engendered by fear. The latest new idea comes in about how we're all going to go to prison if we don't do X, Y, and Z. Everyone goes, oh my God, oh my God, oh my God. Then someone starts doing something and then someone else starts doing the same thing. Then everyone does that thing because it's a thing we can do that we feel relatively safe about. So I think that definitely is one of the effects. And I think far too much money is spent on experts, particularly lawyers, to be honest. When I started in pensions, there were a lot more defined benefit pension schemes. And there are a lot fewer schemes now. There aren't that many fewer lawyers. Why? Because the amount of legislation has gone through the roof. So you need to talk to your lawyer a lot more than you used to. And I think it is really sad that employers now only provide pensions when they're forced to do so. Auto enrollment's great, but why have we got it? We got it because everyone closed their DB schemes because they set them up. And then when things got difficult and they started trying to see ways to adjust it, they were told, no, we've changed the law now and you can't adjust it, or you can't make that change, or you can't do that. Oh, and if you do anything in your business that's going to cause any problems, you can go to prison. No one wants to run a pension scheme anymore because we've scared the bejesus out of them. And my argument is this has definitely not improved member outcomes. So what could be done better? I think it would be great if we could rely on the existing legislation more and not always change it. I was really disappointed that there was a decision to amend the funding legislation to bring in the new funding code. Regulators have been talking about that code for years. They could have done it under the current legislation. They didn't actually turn their general idea into something that was put into legislation, but you get the very distinct impression that no one said, do we have to change the law to do this? They said, we are bringing in a new statute, do we want to? And the reason I'm very disappointed about that is it's a classic example of old law being something that is better because it's better understood. It took us a long time as an industry to understand how scheme funding worked under the 2004 Act. And then we knew it, and then we actually it was working well. So it then gets changed. Why? Did no one think that's actually not a great idea? We need a really good reason if we want to do that. And I really don't think they did. I am really disappointed too that we make no use of trust law. I am amazed actually how many pensions policy people I come across who really have only the vaguest idea about what trust law is and how it works, is a massively powerful tool. It's really, really clear, and it's a great thing to use for pensions because it's all about trying to make sure that the scheme is properly run and gives people the benefits they have a right to. You should draft legislation making use of that, in the knowledge of that, rather than trying to ignore it or codify it. And I found trustee knowledge and understanding one of the most annoying attempts to codify trust law, partly because you really didn't need it, because definitely you need that degree of knowledge and understanding of trust law. Actually, you probably need a higher one. So all we've done, because what people are doing is they're following the thing in the legislation, because we can all read that so everyone understands that easily. What we've done is reduce the obligations of trustees. And when advisors, lawyers say to trustees, actually, you do need to know it a bit better than that, they'll just say, oh, no, because this is what TKU requires of me. So we've weakened the law by ignoring the legislation. Why the regulator needed this rather than, why we needed this rather than letting the regulator perhaps write some guidance notes about what the trust law duties are, I have no idea. I also think that the legislation should promote the middle ground of good actors. The legislation is mostly written with the idea that people aren't trying to do the best they can and that they aren't competent. I think we should expect that employers and trustees are both trying to do the best they can, and that most advisors have a good grasp of what they're doing. Dare I say it, sometimes they have a better grasp than the person coming up with a new policy. And I think we should always be aware that new statutory interference, it's like throwing a rock into a pool. There are ripples everywhere. There are all sorts of legislation we have because there was other legislation that forced people to do things which we now don't want them to do. So I think it's really very important to think very, very carefully before adding to the legislation, rather than just thinking you've got a solution. So is what I want ever going to happen? Probably not. It's a lot of work and it's not a political rallying cry. And I'm afraid pensions have become very political, so people want to look like they're solving things. However, I do find a lot of politicians recognise the problem with the growth of legislation and that pensions is a particular area of problem. Some years ago, when I was chair of the APL, I was in front of the select committee after the BHS thing on behalf of the APL. And Frank Field was musing, actually discussing at me, because you don't really get to be part of the conversation if you're in front of the committee, that there used to be a kind of policy of one in, one out. If you pass a piece of legislation in an area, you repeal one. At the very least, look at it and see whether what you're doing will work well with it, whether what you're doing is needed because of it, whether if you're doing a new one, you really need to take out the old one because you don't need both. But what can we do? I think as an industry, I think we can explain things better to politicians and to the public. I think we can stand up for ourselves a bit better. As I say, I think we're quite good at saying, yes, you're right, we're doing it really badly. But rarely do we say, and if you stopped continually passing legislation every time you saw something you didn't like and you don't necessarily understand, it might work a bit better. And I think if we did that a bit, if we said, look, we don't need a law to tell us that trustees need to understand their pension scheme. We don't need a law because there is already law that does that. Then actually it could move the conversation to something more pragmatic about what it is we might do. I still think politicians are too focused on pensions, and I did a short interview on this recently, just saying I think all politicians need to just take a step back and do less in the pensions field. But I just genuinely think we'll be so much happier if we had less legislation. So I'm going to try and stop sharing now. Have I stopped sharing? Yes, I think I have.
You have, Ros. You have. Yeah, absolutely. That was a fascinating deep dive into your mind, Rosalind, on and on pension law, which was fantastic. Does anybody have any questions? I mean, obviously, Bryn, you might want to talk about the House of Lords, and whether just wheel Rosalind in there and just get her to shake up the House and change it all, just make it simpler. What do you think, Bryn? Is this going to be a long burn, or is this an easy win?
But I've been making notes. It's all been very interesting, and I think we can all agree that there's too much pensions law. But apart from that, there's very little in what Rosalind has said that I agree with. I think the premise that pensions are over politicized is fundamentally flawed. They are inherently a political matter. It's a matter of public policy, and there are deep divides on how that public policy should be implemented. So saying the flip idea that pensions should be depoliticized is simply nonsense. I think you could make a case clearly that we should have less pensions legislation, more considered pensions legislation. The other thing I fundamentally disagree with, that it's all the politicians' fault. Personally, I'd blame a lot of the lawyers, because lawyers are intent on creating opportunities for their clients. The example I always quote is Better Pensions, the 75 SERPS Act. You read the white paper, it's a very simple, straightforward scheme. By the time it was implemented in 78, it was horrendously complicated, and we've had to live with the consequences ever since. That wasn't something wished on us by the politicians. I think everyone should take their share of the fame. The officials in the Department of Work and Pensions, the regulators, we've all combined. I'm sure I've done my bit. Just 2 points from history. The trustees that Maxwell wasn't able to bully were the member trustees. He bullied the employed trustees. He bullied his employees. The people he didn't bully were the trustees being nominated by the trade unions, the member trustees. It was pre-legislation. They had their role, and they supported Maxwell because until the thing crashed, the scheme was extremely successful. And because of his success in achieving a very well-financed scheme, they backed him. He then stole all the money. Maybe they should have been more cautious. But I think the idea that Maxwell's problem was all down to the problem of the Maxwell schemes was all down to the fact he could bully the member trustees is just wrong. I knew them. I had discussions with them. I knew who they were and what they were coming from. So really, don't say that again. I think it's clear that it was his employees who were.
And just to be clear, I don't have first-hand experience. You do. I was told that by other people who have been involved, right. And if that's incorrect, I stand corrected. That's helpful to know. I think the point I was making wasn't so much about the facts about what happened, but that a number of the things that were brought in to try to stop people doing a Maxwell already had. So, and I'm not saying people didn't stand up to him. Sorry, I misrepresented that. I was trying to say someone who's bad sometimes manages to push through even with those controls. And a number of the controls we brought in were things that Maxwell already did, and it didn't stop him because Maxwell was a bad person. Basically, I suppose that was where I was trying to get to. If that makes sense.
Okay.
So apologies.
I think I made my point. First of all, to blame it all on the politicians is clearly wrong. Secondly, it's clearly wrong to think that pensions aren't political. They're not a technical issue. The other historical point I wanted to make is that there's this the old days was so good idea that back in the days of DB schemes, the 70s and so on, that it was all perfect. No, some schemes really screwed their members, and we needed legislation in order to protect the members. The idea that benevolent employers are there protecting the members is again nonsense. So the whole premise, Rosalind, of what you've been saying, I just disagree with totally.
Fair enough. Fair enough. Yes, I didn't mean to give the impression that I thought politicians were entirely to blame. I think it has become political rather than policy, and that to me worries me, in that I think a lot of people get sound bites these days. And I'm not really talking about the legislation that was brought in the early years. I think there are a lot of people who are saying things that are disappointingly not well thought through. That's not me saying I don't think there should be any political intervention in pensions. I certainly don't think that at all. Obviously, I'll disagree with you about it's all the fault of the lawyers. I don't think that, but I didn't think it was all the fault of the politicians. I think we've ended up as a society, if I'm actually going to argue against a group of people, I think media have whipped this up in a way that I find unhelpful. But I don't think that I am in that blaming politicians. I'm blaming where we've got to. My example of the Upskirting Act was a classic example of something where lots of people who weren't involved in being in Parliament have whipped up the idea that there needed to be a law on this, and it became difficult. The conversation got to the wrong place, as far as I could see from a legal point of view. Anyway, that was just a bit of explanation of what I was trying to mean by some of that.
Rosalind, that's fine. What I love about Playpen, what Henry and I love about Playpen is that, you know, we can debate these issues and, you know, challenge, which is what it's all about. So, and pensions is subjective as well, I guess. You know, so Bryn, I really appreciate your honesty and openness. That was brilliant to challenge Rosalind. I know it's her birthday, but you didn't hold back, which is great. No. So that's perfect. Shay, you've had your hand up, and then we'll come to Chris. Shay, do you want to unmute, and then we'll come to Chris.
Hi, Steve. Thanks very much. Rosalind, thank you for a very, very insightful presentation. And I just want to pick up on the 2 points that I think you raised on proportionality and accountability. So I don't know if you've seen some of Julia Black's work where she discusses there should be increased focus on accountability. And I actually had a conversation with a non-UK regulator last week, and they were talking about what I was trying to explain to them, that I thought that if we make the regulated more accountable and we help them, as you were saying, by issuing guidance to help them with a positive slant as opposed to a more defensive strategy, I thought that would be more beneficial. So on this small boxes versus outlying boxes that the pensions regulator specifically is trying to or seems to be trying to check, I think Robin Ellison calls it regulatory creep to an extent. I was just wondering if there was some kind of a group which maybe could be set up, or maybe it exists and I'm unaware of it, to sort of challenge the interpretation that they have at times. Because as you said, so we have a lot of regulation coming out, some of it conflicts, some of it's open to interpretation, and I think we can all agree it's not always the most effective it can be in every situation. I was just wondering if there was a little group of experts sitting somewhere who had the authority to, you know, to oversee what they're doing, what they interpret, and actually challenge it so that they would have to be accountable. Because I mean, so we have great people in the pensions regulator, etc., but it seems to be the same kind of culture keeps coming through. And I was just wondering what your thoughts were on that.
Yes, I think it's interesting, isn't it? I mean, I think we've almost moved away from an idea in the pension space. That this is one of the reasons why I challenge the idea that it's all to do with things lawyers have done, because actually we haven't had enough case law. I think, you know, when employers have done bad things with their pension schemes, they haven't been sued, and they should have been. When trustees have let people down, they haven't been sued, and they should have been. And I wish that the regulator was taken to court more, not because I think they're wrong, but because we'll have a lot more clarity about what their powers are and what their interpretation of things are if that happened. Pensions is an area where, as a lawyer, there isn't much case law. There's virtually none. And there has been a few recently on a lot on one or two quite esoteric points. But if you compared it, say, to employment law, where there are just thousands and thousands and thousands of little cases going through, which give us a really good idea of where employment law stands, which is a really helpful thing for people. And I think it keeps all the people involved, including regulatory bodies, honest is the wrong word to use, because it sounds like I think people are being dishonest. I don't think they are. It keeps them clear about where they stand and what the situation is. And I am disappointed that we don't have enough things. I think the regulators should be challenged and sued, not because I think they're wrong, but because, in fact, it will give them so much more power. If they're challenged on something and the court says, nope, they're right. We've actually recently had a first-tier tribunal case about shared statements on that, which is really helpful, because it's now clear that if the regulator wants to do what the regulator had done, then that's fine as far as the law stands. And I think that's a really helpful thing, but we don't have enough of that. We don't have enough of people challenging each other, because in pensions, we think about it the whole time in terms of regulation and having another regulation and another set of guidance and another code of practice, rather than actually just having law, which is a lot less crude, frankly.
That's very interesting. Thank you very much. Thanks.
Thanks for your question. That's great. Chris, do you want to unmute Chris and make a point?
Cool. Yeah, thanks, and thanks, Roslyn, for fantastic talking. Yeah, appreciate Bryn's points as well. Thank you. The thing I wanted to sort of go through with you is I've had over the sort of past few years a number of talks with employers who might be interested in collective defined contribution schemes, and probably the key thing they're worried about is the law changing in future, and the political parties agree now what they want, and you know, everyone, the law as it stands is great. It's what they want to go forward with, but they're terrified of the law changing in future and having these big liabilities sort of imposed in a backdated way on them. And I know efforts have been made to make the law work in that way for collective defined contribution schemes, but I just wondered if there were any sort of other thoughts you had and any other ways that could be done.
I absolutely agree. It's a real problem, and it is a problem of the history of what we've done. I'm coming back to Bryn's very valid point. None of these sort of changes that were brought in for bad reasons. They were brought in to protect people, but there has been a cumulative effect of that, and to an extent, I feel that it's not acknowledged often enough. So I'm having exactly that conversation when Steve Webb was minister, and when he was first presenting the idea of defined ambition, and I was at a conference where he was presenting it, and a couple of people raised the point, exactly your point, Chris, which is this is great to have certainly when he talked about DB Light, this is great, but that's what the people who set up DB schemes in the 60s thought they were setting up. Now, there are good arguments that really they shouldn't have thought that, because people thought they were getting a definite DB pension, and then a lot of people lost out on it, and that's not good, obviously. But I think that's why DB Light, as a kind of that side, the defined ambition side, never really came forward, because that is far too close to what DB was thought to be by some people historically, and it's too at risk of regulatory creep. Because the point is, pensions are a really important thing, and it's incredibly high profile. And so what if someone has a CDC scheme and then loses out and thought they were going to get something and they didn't, and actually it's a really complex thing, and maybe the person it was explained to didn't understand it properly? Are we going to end up in a situation where the way that's dealt with is by funding? I mean, I'd hope not. I think we probably, even if people don't talk about it, they acknowledge the lesson that the regulation has driven everyone away from the market to some extent, and don't want to go back there again. So I would hope, and I think when you talk to people who are involved in CDC, they're absolutely emphatic that, they will crawl over broken glass to make sure that doesn't happen. But it is a really hard sell, and my own theory is what we need to do with CDC is we need to have some CDC master trusts, and I think some of them are quite interested in that, which is great. And then when we put up the auto enrollment contribution, we put it up a bit less for the employer if you do CDC. I think we need an incentive to kick people into CDC so that they are doing it. I understand from people who understand, like you, Chris, who understands the numbers better than me, that CDC has real advantages over plain DC. So I can see that attracts them, but I just don't think you're going to convince people if you don't kick them with something. basically.
Cool.
Okay.
Thanks, Roland. Yeah, I know they've done everything they can to assure everyone that the benefits will, that the legislation will carry on in the future. But yeah, that's great. Thank you.
And actually, just to make the obvious legal point, which may or may not be obvious, which is the supremacy of Parliament, which is you can't pass an act of Parliament saying you're not going to change it in the future. We can, but it doesn't work. So the new government can come in and change it. As my father knows, because he wrote a book on labour law on the Industrial and Labour Relations Act 73, and it published about 4 weeks before the incoming Labour government repealed it. So, you know, which my father was very pleased about because he didn't think it was a very good act. But the point is, he'd written a whole book about it, and law can just be swept away by an incoming government or by the same government. That's the power of Parliament. That's how it should be. We vote for these people. They should have the power as to what the law is.
Okay, Rosalind, thank you. Jane, you had your hand up for a while. Do you want to ask a question and unmute?
Yep. I'll come off my camera and I'll also disclose my name, which for some reason isn't on there, which is Wolstenholme, for those of you who don't know me. Some of you will recognise my face anyway. Thank you very much, Rosalind. That's very interesting. I had a question, but first I was going to comment about the TPR stuff. Because having been until about 2 years ago at TPR, and appreciate there's a lot of change of management. The thing about TPR being sued more, the legal team would have loved that. Now, cynics and Moxley will say that's just lawyers wanting more work, but actually it was mainly for those reasons that if we did things and then got the court to uphold us, then that would be great. If we did things and got the court to turn us down, at least we'd know. Yes. Whereas the legislation was quite complicated, but there was an enormous nervousness amongst the management, certainly at that time, about being sued. And of course, the other problem is that the way that you would challenge the decision of the pension regulator is judicial review, which is a long and slow and complicated process, and you can't just do it. You have to get permission. So that in itself makes it harder, I think. So that then brings back to the other comment about should there be another body that can review what the regulator's doing that isn't the court. But that is that would be more legislation. My actual question, the reason I put my hand up, was do you think that part of the problem is that they're trying to shoehorn too much into pensions? I'm thinking particularly of, we'll get pensions to do investment with ESG and that will solve our climate crisis. I'm not saying that climate crisis isn't real, by the way. I'm not a climate change denier. I am slightly nervous about whether just making pension schemes and other people say how they're going to invest things is going to fix that. I know there was a theory behind it. And then also the Mansion House stuff. Is it really getting pension schemes? You know, I am a trustee of a pension scheme as it happens. We should be investing in the interests of our members in what we think is the best thing for our members. Is it our job as trustees to sort out whether a UK PLC is attractive enough? You know, it's possibly more of a comment than a question in that itself, but because I know what I think, but I want to know what you thought.
I mean, I really have that thing about climate change. Also, good to see you, Jane. Haven't seen you for ages. So hi. Yeah, I have that thing about climate change that you have. I found it really frustrating because I'm nervous about people thinking that will solve the problem. That you know, climate change is a really big thing. You don't solve it by asking pension schemes to tell you what they've invested in. You know, and I appreciate that there is a nudge factor of that, and it makes people more alert and aware, and that's no bad thing. But it's not so much that I object to it, it's that you don't want it to be your policy. You don't want it to be the only way you're solving it. If you're trying to deal with climate change, I think it's great to have all these requirements there.
Yeah, and I think we're back a little bit to virtue signalling. What have we done about climate? Well, we've passed all these laws.
Yes, exactly. Whereas actually, you know, that can't be your whole policy. That's my big worry with it. And the same with UK PLC. It rather smacks of something. I have a lot of my family work in academia, and a lot of my family get quite cross about the push for them to take a higher proportion from you know, poor inner city schools. Not because they don't want to, but because the problem is that those kids are getting a really poor education, and they often can't, you know, if they've had a really dreadful education, however brilliant they are, they may find it very difficult to keep up at university. And it's not that they shouldn't be pushed to do that, it's that should not be solution to the fact that the inner city schools are failing. There needs to also be a solution to the fact that the inner city schools are failing. I say fact here, that's because I have a lot of family in education. They will get very angry about it, and they'd shoot me if I said that was an opinion, not a fact. So, you know, I think that's the same problem. We need to not be trying to solve all our problems through a pension scheme, but that doesn't mean we can't have the pension schemes be part of the solution, as long as they're not the whole solution. I do think they're too front and centre, and I don't really know why.
Okay.
I have a cynical theory I should throw out, which is just that the first big pension scandal in the UK involved journalists. And so, you know, those people were aware, and journalists feel very sensitive about pension schemes, particularly, and it all gets good copy. But that's partly because I'm married to a journalist.
There you go. There you go. Rosalind, absolutely fantastic presentation. Lots of great questions. Thanks for everybody's input. We are at the hour, and really, really fantastic. If anybody like a copy of the slideshow with all the slides that were missed, then you know, we're very happy to send that through. And yeah, Rosalind, fantastic. Thank you for putting your time on your birthday. And yeah, really, really, really appreciate that. And as usual, we pray for peace in the East. Oh, Peter, you got your hand up, or is that a clap? I don't know, Peter. Is that a clap or a hand? Do you want to unmute, Peter?
It was meant to be a clap, but
there we go.
apologies for that.
a birthday clap. So, but no, Rosalind, on your birthday, giving up some time for us is absolutely fantastic. And yeah, we should keep challenging and keep pushing, and hopefully we can get some of what we want. So, and there's happy birthday messages as well in the chat, Rosalind. So, but cake and champagne, you know, will be on its way. So there you go. But thank you very much. The recording of today will be on Pension Playpen this afternoon. As usual, we pray for peace in the East. Absolutely, Henry, and peace in the Middle East. And next week will be 2 days before the election, so we might have a pre-election special. Henry and I might work on something there, but next week, if you can join us, it'd be great to see you all. We really appreciate your input, your questions, and we hope you enjoyed the session. And enjoy the rest of your day. Rosalind, especially, enjoy the rest of your birthday. Lots of surprises and cake, and enjoy your play. You're going to see Witness for the Prosecution. So, yeah.
Lawyer's birthday.
A lawyer's birthday in a courtroom. How apt. So there you go. Anyway, appreciate your input, appreciate your time, Rosalind, and enjoy the play. So thanks very much indeed, everyone. Take care. Thanks a lot. Bye. Bye.